A U.S. District Court judge has granted a preliminary injunction against the Los Angeles County Eviction Moratorium because he says that it's too vague to enforce. I'm Tony, and this is Real Estate Investing and Landlord News. All right, so I have some good news for landlords in Los Angeles County, California. A judge has granted a preliminary injunction against the Los Angeles County Eviction Moratorium, okay? And this is to be expected because the laws they put in place are so complicated, so convoluted. Landlords, they didn't know what part of the law they should be listening to, what they should be doing. They had no clue what was going on. Okay, and the judge agrees. They said that it was too vague, too complicated. Nobody knew what they could or could not do, and they basically put landlords in a horrible position where they had to attempt to interpret the law without breaking it. And that's not where people should be at, okay? And by the county putting all this garbage in place, there should have never been an eviction moratorium, in my opinion, right? But by them putting this law that was so complicated in place, they made it impossible for landlords to be able to operate their business and know what they could and couldn't do. So before I get into the article, go ahead, hit the like, subscribe button, maybe leave a comment down below. Let me know what you think, okay? For the Los Angeles County landlords who are watching this video, okay? What did you think of the county's eviction moratorium? And remember, this is separate from the Los Angeles City eviction moratorium. Did you think that the law was complicated? Did you think it was hard? I'm going to explain as I go through this article, because they have in good detail why the judge found the way that they did and why they had to toss that eviction moratorium to the curb, okay? So let's get into it. So this article is coming from courthousenews.com, and it says, LA County's new COVID-19 tenant protections are found too vague to enforce. Let's get into it. A new set of COVID-19 tenant protections that replaced Los Angeles County's residential eviction moratorium earlier this year is too vague and can't be enforced, a federal judge said. U.S. District Judge Dean Pregerson on Wednesday issued a preliminary injunction against enforcement of the eviction protections effective December 1st. The judge agreed with the Apartment Association of Los Angeles County and the Apartment Owners Association of California that the protections that took effect on July 1st, 2022 are unconstitutionally vague. That the tenant protections are difficult to suss out is not sufficient to render them unconstitutionally vague, the judge said. The question, rather, is whether the resolution gives the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. And that's the problem, right? If you are a normal person, right? Anyone who isn't a highly trained lawyer, you couldn't make heads or tails of what this law said. It was that complicated, okay? And just trying to read the various parts that they put in place at different points in time, you wouldn't know what you were supposed to do. That's what this judge is saying right here, okay? And it makes no sense to me whatsoever why they implemented it this way, other than the fact that, hey, they knew that they wanted to make landlords suffer and they wanted to give tenants free rent forever. That's what my personal opinion is, okay? They're trying to get this socialized housing stuff going where basically private property owners are providing the social welfare and the social housing that the government should be providing. That's stupid, okay? Do not tell a business owner that they have to be the homeless shelter or the free housing provider for these people who can't pay their rent, okay? The county, like the state of California and the city of LA, imposed restrictions on landlords so that tenants who lost their income when the pandemic first swept through the U.S. in 2020 wouldn't end up on the streets. In January, the County Board of Supervisors passed a resolution that its lawyers argued began a multi-phase termination of all county tenant protections related to COVID-19. However, according to the judge, that resolution incorporated over a dozen prior resolutions and amendments related to COVID-19, resulting in a document that lists across several different sections and subsections different types of protections applicable at different times to different groups of tenants. Yeah, so it incorporated more than a dozen prior resolutions, and that's why this whole thing was so complicated. Instead of nullifying all those previous resolutions, they're like, oh no, we need to protect this group, that group. You need to do this, that, this. Landlords are like, what the heck? I don't know what I'm supposed to be doing here. Other than that, right? We can't evict anybody, and if you take that risk, you risk being sued or fined by the city. You put landlords in a bad situation. So yeah, I am glad that the judge was clearly able to see that this is a mess. The section that deals with eviction protections asserts that while there is no longer a total moratorium on evictions, a limited pool of tenants with a household income equal or less than 80% of the area median income and who aren't able to pay rent for reasons related to COVID-19 are protected from eviction, according to the judge's findings. But another section of the resolution says that this protection only provides an affirmative defense for a tenant in an unlawful detainer action. Thus, under the county's interpretation, the current tenant protections do no more than provide an affirmative defense to a discrete set of tenants under relatively specific circumstances who are already involved in unlawful detainer proceedings. But yet another section of the county's resolution prevents a landlord from bringing an unlawful detainer action at peril of civil and criminal penalties unless the landlord reasonably believes that the tenant's affirmative defense will fail. And it is impossible for a landlord to know whether or not such a defense will end up failing, the judge said, because of the seemingly unlimited COVID-19 related reasons a tenant can cite as reasons why they can't pay their rent. Without any meaningful guidance from the resolution, landlords are left to guess, not just as to the likelihood of success of any unlawful detainer action, but as to whether the very filing of any such action is prohibited, the judge wrote. Attorneys representing LA County in the lawsuit didn't immediately respond to a request for comment on the decision. So yeah, let's go back a couple of paragraphs there where it says here that, if a landlord brought an unlawful detainer action, they risk facing criminal and civil penalties. Okay, so that you're basically saying, hey, if you bring an eviction action against against the tenant, and they actually are protected by these eviction protections, then we could throw you in jail. We could fine you. You could get a criminal record because of that. And it would be of no fault of your own because, as the judge also said, that there were a seemingly unlimited related reasons a tenant can cite as reasons to why they can't pay their rent. Okay, so a tenant has 1,000 excuses. They went through and they were, we're going to give a tenant every excuse known to man of why they can't pay their rent. That's ridiculous. Okay, there's only one thing a landlord needs to know. Is the tenant paying or is the tenant not paying? All the little personal circumstances, if you lost your job, if you're sick, all that other stuff is irrelevant, okay? Always has been irrelevant. The only thing that changed was that COVID-19 happened, and all of a sudden they think that they can just change the laws and make it so landlords have to eat losses. And that's wrong, okay? It is dead wrong. And I'm glad that this judge, put an injunction on these stupid rules that they have in place. Unfortunately, I believe it's said up here that the injunction doesn't take place until December, which is 2 months from now. Give me a break, okay? Why can't the injunction take place right immediately? This law has been in place since July 1st of 2022. So, and it says the injunction against the enforcement of the eviction protections effective December 1st. So, the judge didn't make it immediate, so landlords still are going to have to suffer through a couple more months of this ridiculous nonsense. But they just need to get rid of it. Okay, they need to end all of these eviction protections and get back to a normal way of life. Okay, we're never going to have a time period when people aren't suffering some kind of financial trouble that is preventing them from being able to pay rent. That is no reason to have an eviction moratorium in place. Like I said, private business owners should not be made into the low-income housing providers, the social service providers for, the low income and the homeless. That's ridiculous, and I'll never agree with it.